All right, welcome back, everyone. Craig Steger here. Sorry I'm late, as I usually am. Just working, just busy afternoon. Actually, I was working on the type of case that I wanted to talk about today, which is adverse possession. And I was wrapping that up right before I got on here. So I appreciate anyone who hops on the chat during the live stream or if you comment later on. For those that don't know me, I'm attorney Craig Steger. I practice in Wisconsin, Minnesota, and Iowa. Before I talk about today's subject, which is adverse possession, something you may or may not have heard about, but I always find it to be a very interesting, it's almost an antiquated idea. And when I actually do get to work on a case, it's kind of fun. So I'm kind of excited to share a little bit about that with you. Before we get going, though, I do want to go over the unpleasant part of this. So, just a reminder: this live stream is for informational purposes only and does not constitute legal advice. Viewing or participating in this live stream does not create an attorney-client relationship. You're certainly encouraged to participate, to add any comments or questions that you have in the live stream or in the comment section after the live stream is over. If you have general questions, I'll do my best to answer them if I can. I may do a video later on about that. But what I encourage you not to do is to ask any specific legal questions about a matter pertaining to you or someone close to you. Those are the kinds of things you want to talk about directly with an attorney who practices in the state and area of law that your issue deals with. For me, I can only help people in Wisconsin, Minnesota, and Iowa. So if you have an issue in one of those states and want to reach out to me, feel free to go into the description below. You can find my contact information, and you can always call or text me at 608 205 8826. Someone will get back to you if we don't answer and get you information on how to get on my calendar. So, with that in mind, let's go ahead and get started. So, adverse possession is today's topic, and I'm going to pull up, if I can, my notes that I was working on today. Because, like I said, I actually have a adverse possession case that I was working on today. They don't happen a lot, but you'd be a little bit surprised at how often they do happen. So what is adverse possession? So basically, adverse possession applies to interest in real estate. I don't know that you can obtain adverse possession in non-real estate, non-real property. That I'm not sure about. Um, but for purposes of this discussion, I'm going to talk about adverse possession as it relates just to real estate. And basically, what happens is this. So, real estate, at least in the United States, is sort of very methodical about how you determine ownership. Back in especially most of the country, so the Midwest and West, was, let's say, largely raw wilderness land until the 1800s, when they really started surveying it and laying out a consistent grid of real estate across the country into quarter sections and half sections. I'm trying to remember what the breakdown is. Acres in a section. What is the size? So a full section is 640 acres. Half section would be 320 acres, and a quarter section is 160 acres. And I believe in a lot of the U.S., in the Midwest, where, let's say, where the ground was relatively fertile, you could homestead 160 acres, so quarter section. 160 acres was sort of, I think, viewed as the amount you needed to run a normal farm. Um, but regardless, what they did is they basically laid out all the land in this grid pattern of sections and quarter sections. And I'm trying to think. I think a section might be a mile by a mile. Let me think about. Let's see here. I'm trying to remember here. A section of land is 640 acres. Why did I think it's a mile long? That I'm not sure about. But anyway, they laid it out in a grid with very at the time kind of rudimentary but accurate transits and other surveying devices to kind of lay out, and then at the various points they would drive like a steel marker if they could, and that was kind of always memorialized. So usually most real estate is based off of these steel rods pounded deep down into the ground at the corners of sections and maybe the quarter sections. I'm not sure how much smaller they get, but you can always add additional monuments at smaller parcels once you if you start dividing up the land in less than quarter sections, which is certainly very common now. And then property descriptions is based on this system where let's say you might own the northwest quarter of the northeast section of this township and all this and that, and that's how they did. It was all laid out in a grid, a big plat map, and you could point to this piece, this corner of this piece of this section, whatever, and determine who the owner was, and they would record who the owner was in this book. And then when you would sell the property, they'd change it and they'd identify who the new owner is, and that usually is conveyed in some sort of a deed, a written deed that describes in as detailed fashion as necessary who the owner is and what the dimensions are of the property in dispute. And then that gets recorded at typically the recorder's office. That's what it is in Wisconsin, but it's usually maintained at a county level by as part of the court system, or at least the county government system maintains these records. And so that's how you transfer property is you could before you obtain property, you would go down to the courthouse or someone would go down and review it and make sure that the person that's trying to sell the property to you is actually the owner of it and there aren't any outstanding or other liens against it, such as mortgages, judgments, easements, shared well agreements, things like that. Those are all kinds of things that can encumber clear title. And so what happens is in the past, especially in an area around here, so we're in the driftless region of Wisconsin, and it's very hilly, and a lot of the land around here was used for agricultural purposes. And so it was common in the past. It wasn't necessarily easy for farmers and landowners to be able to tell exactly where their boundaries are at, and so they might do their best. They might step it off, and or they might kind of go with the lay of the land and lay a fence in an area that made practical sense for both sides in terms of being able to get to it and maintain it and all that, and where cattle and water would be. So you would have these fences, a lot of times fences. That was kind of where a lot of this started. Fences put up, and fences typically are a type of boundary. It's a physical barrier, both keeping your own cattle in or your neighbor's cattle out, but also, in a sense, declaring, "I am the owner of everything within this fence, this enclosure." It could be other things. You could put up a wall. You could build a building. I mean, a structure is a very much um, a much more permanent indication that you own something than even a fence. But regardless, adverse possession is based on the idea if you treat someone else's land as your own for a long enough period of time, you actually become the owner of that property. You adversely possess it against the actual property owner's interest, and despite the fact that someone else actually has the deeded interest, the titled ownership of this real estate. And I think historically there was some different reasons for that. One is there was this idea that land shouldn't be wasted. So if someone isn't making use of land and someone else goes out and actually makes use of it and does it long enough, they should be entitled to ownership of that property. And I sort of wonder if it doesn't relate in some way to what I was talking about earlier, which is, how property used to be homesteaded. And so you could get your free quarter section of land. And then if you went out there and you planted crops, planted trees, built a homestead, and you lived there long enough, you would actually get to keep it. But you couldn't just, hey, this quarter section's mine, and then head into town and do nothing with it. You actually had to do something with it in order to actually gain title to the property under the homestead laws. It could be that this is sort of it's kind of built on the same concept, but the idea being is land should be put to use. It shouldn't be wasted. And if the real landowner isn't out bothering to check whether someone else is running cattle or building fences or building structures on their property, tough luck to them. So that's what adverse possession is. It varies by state how long this needs to go on before you acquire the real estate. In Wisconsin, at least the one I'm working on today, is 20 years. In some states, it's maybe as short as 15 or even 10 years. In other states, it could be 25, 30 years. I'm not sure what it is in Iowa and Minnesota, but 20 to 25 years is a pretty common time period. And it doesn't all have to be by one person. So if I buy this property from George, and before I bought it, George what had his fence and he was making use of this strip of land belonging to the neighbor. He does it for 10 years, sells it to me, and then I do it for another 10 years. Combined, that 20 years may be enough under, let's say, Wisconsin law to be able to adversely possess that. Now, you have to do certain things, so it has to be open and obvious. It can't be, well, I just declare that I own the land down to the creek or whatever. You actually have to make overt efforts that's obvious to anyone, including the actual owner, that you are claiming this as your own, which is where farming operations, buildings, things, fences, planting trees, stuff like that comes into play, because that's what's used to determine whether someone is actually um, doing this notoriously and openly and obviously. So that's what happens with adverse possession. Now, what can happen, of course, is people dispute. Here's an example. If someone asks the neighbor, "Hey, is it okay if I put up a fence down on your part of the property, and can I fence it in and put my cattle on it?" And if the neighboring owner gives you permission to do so, even if they don't charge you rent, that generally will prevent an adverse possession claim because it's done with the landowner's permission. So permission is generally a defense to adverse possession. You're allowed to let other people use your property, and if you do so, they can't they can't become owners of it if they do it long enough. So it's something that's done openly and notoriously and adverse. The person that's using it is saying, this is my property, not that I'm using it, not that the neighbor gave me permission, but this is my property and no one else has any interest in it. And that has to go on for a long period of time. Like I said, in Wisconsin, it has to go on for at least 20 years. So, correct. So, a lease and rent, even though the actual, you are treating the property as your own if you move into the house, but it's being done with permission. So, as long as it's being done with the permission of the owner, whether they're charging you or not, that isn't going to qualify as adverse possession. Now, I know that there may be some specific landlord tenant rules. I know some states seem to have some kind of squatters claims and things like that. In Wisconsin, at least, we have landlord tenant rules that basically dictate how you can kick someone off your property after you have allowed them to come on. But from the standpoint of adverse possession, if you're using someone else's property with their permission, you're probably not going to be able to meet the elements of adverse possession. Um, I had a case probably 10-15 years ago, which was kind of interesting because, as I mentioned to you before, a lot of real estate is ideally, based on monuments and pillars that are driven into the ground, and they don't change, right? That's the idea, is they stay the same. Well, you can always dispose of part of your property, and you can sell it off, you can lease it, you can do what you want, but you have to wait. If you're going to do that, you have to have a way of defining clearly what it is that you're giving up. So it was common. I don't know if it was how common it was, but it was common in the past. They'd say, I give you all the land up to the bank of this river or this stream, right? And that's what I had. I had a case where that was exactly what happened. They said, we transfer all of the real estate up to the edge of the Kickapoo River. Well, that land was transferred, let's say back in the 1920s or even the 1800s. It went way back, and then it stayed in this family for a long time. And then fast forward 50, 75, or 100 years, and suddenly the Kickapoo River isn't where the Kickapoo River used to be because they move. You have flooding events. It is, you watch a map, especially even the Mississippi River, which is just down the street from me here, has changed. It changes over time. It's not static. This is especially true in like smaller streams, and rivers and things can really change over time. And so that's what happened in that case. Is it amounted to, I don't even remember, 20 or 30 acres. It was an extremely it was a quite a bit of land, and I think it had moved like 80 feet over the course of 75 years or something like that. So that can be one of the hazards. The other thing is, it was not uncommon for, especially for farmers, to transfer 20 or so acres up to the line fence on the north side of the property or something like that. Well, the problem with that is fences can move. Fences get, if you don't do anything with them, they tend to fall apart, deteriorate, and you got to build them up, or they get moved. And so you can have these kinds of disputes as well, or oftentimes, you put the fence where you think it is, but in some parts it might be exactly where it's supposed to be, and other paint, you're trying to go around some obstacle or whatever. It may not necessarily reflect the actual boundary line, especially in hilly country like we have here. And so that's where you get these adverse possession cases, because no one really knows exactly where the boundaries are at. So you might put up a fence, and everyone kind of treats that as the fence, as a boundary, and for the most part, everyone is okay with it. Well, what has happened recently, and this is kind of what led up to this case I was working on today, is now we have much better access to GPS data and information about where boundaries are at. So a lot of hunters will, or well, hikers or whatever. You can get an app on your phone, and you can open up and you can check it. You could check very closely where the boundaries are at, so that you make sure that you're hunting on the property that you have permission to be on, and not on the neighbor's property. Well, sometimes that reveals for the first time where boundaries are actually at, and that's what happened in this case. The problem is that what happens, and this is where people have to be careful. You may find out, oh, this is actually where the boundary line is at. Says right on the GPS. I checked. I had a surveyor come out. Yep, this is actually where the line is. And sometimes people will say, well, that's my property now, and they'll bring a bulldozer out. They'll start cutting trees down and things like that, because, well, I'm the titled property owner here. I just got a survey. Well, the problem is the other property owner, your neighbor, may actually own that now, even though it doesn't say so on a deed. If they've adversely possessed it, that property is actually theirs now, and you may be liable to them if you cause a bunch of damage to what is now their property. And that's what happened. That's what happened in this case. So I'm, preparing to file a lawsuit on that case, and there's a variety of claims. So there's adverse possession. What other ones is there? There is, let's see. Trespass, that kind of deals with like damage to the trees and bushes. Conversion is sort of the fancy name for, like, if you take someone's property or destroy their property, that's called conversion. Waste, punitive damage, negligence, nuisance. We actually have statutes in Wisconsin. I'm not sure about Minnesota and Iowa, but we have a statute. I think it's 26, chapter 20, section 26, deals with if you cut someone else's logs or trees and things like that, there are penalties for that. There's actually requirements that you get survey and stuff like that. So there's a whole host of claims, but basically what you do, if you believe you have adversely possessed someone else's property, or on the alternative, if you're the titled owner and your neighbor claims that it's their property, either side can start a lawsuit, go into court, and bring what's called a declaratory judgment claim. That means that they can bring it before a judge and ask the judge to decide as a matter of law who actually owns the property in dispute. And that's what's going on in this case. It's just unfortunate that there was a bunch of damage done to the property in dispute. Now, if the original landowner wins, then it's no harm, no foul. But if the judge says, no, your neighbor adversely possessed it, now what are you going to do about all the damage you did, thinking it was your property? And so that's the kind of stuff that can happen. So, it's just really important, if you get yourself into a boundary dispute with your neighbor, or you find out for one reason or another that the boundary isn't where you always thought it was, don't just automatically start doing things, tearing things down, putting fences up, all that kind of stuff. I've seen all of that stuff happen. You can't just start doing that, because you may not actually be the owner of that property anymore, and it may be something that happened before you ever became the owners. And so you have to be very careful and actually bring legal action and have the court decide for sure who is the correct owner. And there may be a survey, a revised deed filed, and things like that. So that's something to keep in mind. That's what adverse possession is. It's like I said, it's not super common, but it still happens. It still happens pretty regularly, and so that's one of the cases that I've been working on recently. Yeah, that's a good. I'm going to put this comment up here. Yeah, I mean, um, that's just a good attitude everyone should have. Um, take good care of it, treat it like it's your own in a good way, not in a bad way. Treat your neighbor's property with respect. A lot of times around here, at least, neighbors will, agree to maintain the fence together. There may actually be laws that require the neighbors to split the cost of it, things like that. But there is a whole host of rules that apply to like landlord and tenants, so tenant situations where you have leases and things like that, that is kind of outside. It's sort of in its own separate world. This isn't really dealing with rental situations. It's dealing with actual property owners next to each other, and then they get into a dispute as to who owns a particular piece of land if it hasn't necessarily been always used consistent with the actual technical boundaries as they're recognized down at the Register of Deeds. So if anyone has any questions about adverse possession, feel free to leave it in the chat. And feel free to leave it in the comment below. But this is, everything that I've talked about here today really is specific to Wisconsin. Every state has a little different system in terms of well, primarily on the time period, so how many years it has to go on, but also what can and can't constitute adverse possession, what is or isn't hostile actions. That can vary greatly by state, and so you want to make sure that you talk to an attorney in the state that you're in that is familiar with the nuances and specifics of adverse possession in your state. Or if you're owner and you want to make sure that you have clean title, you can have a survey done. And if there's any question at all, you as the rightful property owner, you can start your own lawsuit and have the judge to say, hey, as a matter of law, you are the correct owner of it, no one else has a claim to it. Then you're much more free to go ahead and do what you want with the property, build on it, cut trees, plant trees, all that kind of stuff. So anyway, well, I think that's all I wanted to talk about today. It's just after 5 o'clock. I'm gonna head over to the gym and then get the weekend started with my family. So I appreciate anyone who showed up for the live chat and leaves comments after the fact. I should be back at it again next week. Oh yeah. Hi, Pickin. How are you? Um, yeah. So they say that ignorance isn't an excuse, but does the law give any wiggle room to someone who would have had an understandable reason to assume land was still theirs? Um, that's a good question. I mean, uh, I think it is. I think it is easier. I think it is better if you're using the land the way that it's been used in a long period of time, as opposed to like the situation I described, where suddenly you find out that the fence line we've all been honoring all this time isn't it, and then you go in and tear it all out. So I think it probably comes down to how has it historically been used, and what information do you have as to who is the owner, the type of use. I mean, I think as a general matter, the more damage and destruction you're doing to a piece of land, the more careful you have to be. But like getting back to like the timber cutting statute I was talking about here in Wisconsin, it has a whole thing in there about what is and isn't reasonable. Um, I'm trying to think the language of it, but like I said, so like loggers, so those who actually do the tree cutting, I believe are generally required to do certain things. Like I'm not sure if they're required to hire a survey, but it may not be enough for them to ask the landowner, hey, where's the property line at? Because landowners don't always know. And it may not be enough for the logger, for those cutting trees, to go out and say, well, the landowner said this is where the line is at. Well, you're probably required to do a little more than that. And under our statutes, you have to like check land records, maybe get a survey, do some measurements and things like that. But it's pretty deferential to the property owner. And so if there really is no reasonable mistake. If you cut trees on the wrong side of the property, you're probably going to be liable. So that cutting trees is a big thing. If you're mowing your neighbor's grass, probably not as bad. Or you put up a fence, fences can be taken down. But cutting trees is where you have to be especially careful, because trees can't just be replaced, right? Or cutting limbs down. So I would say when it comes to trees or bushes, things like that, that's where you have to be the most careful, because if you're wrong, you can't just undo those things or fix those things easily the way you can with moving fences and flower beds and driveways and stuff like that. So trees are kind of sacred, so be careful with trees for sure. Let's see, anything else? And I don't know, this may, and the rules may be different in different parts of the country. Wisconsin, for example, we had a lot of, still do have a lot of woods. And so there was a lot of logging for like the paper mills and things like that. And so these statutes are, there's just a lot of logging that regularly takes place in Wisconsin that may not take place, let's say, in Iowa as much. I'm not sure if Iowa has a similar rule or not. Iowa is much more of an agricultural state even than Wisconsin, so their rules may be more slanted that way. I haven't handled an adverse possession case in Iowa to know for sure, but I'm going to probably figure that out at some point in time. Let's see. I think that's kind of it. So I'm going to go ahead and wrap this video up. I appreciate you who were in the comments. You asked some very good questions. Appreciate you showing up in the live chat. If people have questions after the fact and want to leave a comment, feel free to do so. But as I mentioned earlier, if you have a specific legal question, don't put it in a comment. Contact a lawyer directly and ask your questions so that they can help you, and your questions can be confidential. So, all right. Hope everyone has a wonderful weekend, and we'll see you all next week. Until next time, everyone, have a good one.